As a credit manager, I'm a strategic opportunist. I like to have multiple choice. And if I'm to the point where we're having to file a lien or I'm looking at suing a customer to get our money, I'm always a more is better kind of woman. I want to get your attention. So I'm looking for trigger points. Obviously, I haven't found anything to this point. I like to file that lien in conjunction with a lawsuit and any avenue that I can do. What's your take on that? And from an attorney standpoint and a collectability standpoint, what are your best recommendations for how to go about that when you're trying to collect your money?
Sure. So if we're filing suit, we're going after everything. So if we've preserved our lien rights, if we have a contract and lawsuit is filed, we're going after number one, the lien, because it's the greatest privilege. Number two, we're going after the contract. Number three, if there's anything else under the law, be it negligence or some other standard, we're asserting all of those claims,
Okay.
and we're going after it all. So yes, I think if you made the decision that we're going to court,
Okay.
go after it and get it all done. You've got all these different avenues that you can pursue, as you've just mentioned. You've got your lien, you've got your contract, and then just under the law, you have that. There are certain states, though, we talked earlier about pay if paid and pay when paid provisions. Even if you have those provisions in your contract, many states hold that you can still pursue a direct cause of action against the bonding
Okay.
company because they are not entitled to rely on those payment defenses. So even if you have voided your claim by signing the contract where you have a pay if paid provision, you can still go and have a direct lawsuit against the bonding company. So you can pull them into the case as well.
Everything to do with the whole mechanics lien process and also with the Miller Act and Little Miller Act are all time sensitive and they're all tied up together. So if you miss a timeline, is there like a little bit of wiggle room? Can you work some attorney magic to help a girl out? How does that look?
Usually no. Most states, in my appreciation, strictly construe their statutes on lien laws because it is such a strong right where you're getting to take someone else's property. The courts generally strictly construe that, meaning you have to follow every little letter of the law. You have to cross all your T's and dot all your I's. So try for it, but generally there's no wiggle room. So know what the deadlines are, give yourself a cushion, and comply with those deadlines and do it beforehand.
But you said something that I found really fascinating, and I wanted to make sure that other credit managers got the benefit of that. And that's the attorney demand letter. And I'm a huge, huge fan of that, where I can send you a letter from, Thea Dudley says you need to pay me. And like, yeah, girl, you've been chasing me for money all this time. I can ignore you by email, phone, and text. I can ignore your letter.
Sure.
But you get something outside of my company with that very official legal look on it. And I'm a big fan of 5 days. 10 days does not work for me. I'm a big fan of 5 because 10 is too long and it's 5 calendar days. I don't care, you know what you did, you didn't pay me. I love the attorney demand letter. Is that something you recommend?
It's something I always recommend. I send them out weekly. I sent one out yesterday morning for a client who they were terminated for convenience. And I drafted the contract which says, if you terminate me for convenience, you have to pay me for all of my overhead and profit on work that I didn't perform, because I would have been making profit somewhere else.
Okay.
So he's owed a couple $100,000 on profit for work that he didn't do, but the owner just terminated him because they didn't feel like doing the work anymore.
Okay.
So what we did was send a settlement demand. And look, we'll take X amount of dollars, pay us in 5 days, which is what I did on this one. Or we're going to come after you for the full amount.
I love when great minds think alike.
and we're coming after you, and because I drafted the contract, there's an attorney's fees provision in the contract, and so if the claim isn't settled, then we will move forward with the litigation process.
Okay. It still goes back to setting up that relationship. Not only do you need to read, but the relationship and the resources. And
Sure.
that's one thing that credit people maybe are notoriously not as great at, is getting those relationships, because everyone thinks, I can't afford you, you're going to be super expensive. What I like to remind people, especially credit and CFOs, and you can't afford not to have a relationship with a good construction litigation attorney that you have that relationship with, and that you have resources you can use to pop in that question and go, okay, what's going on here? So at least I can have an intelligent conversation.
Sure. Yeah, I mean, it takes that one lawsuit, one loss, one lack of payment, hundreds of thousands of or millions of dollars, where it would have taken you a decade or more of phone calls with your attorney or contract negotiations to make up. So all it takes is that one issue. And what we find a lot of times is how clients may come to us is, well, I was doing it all on my own, and then I just lost out on this big claim, or I didn't get paid, and I'm worried about the company going under, or we're having to lay off people. Why didn't I call you before? And it's just pay a little bit now to avoid paying more later.
I think that's good advice as far as using mechanics liens, checking out who you're doing business with, reading your contracts, having your resources. So you just put that in a nice little nutshell for us. Thank you. So that wraps up lesson 2. Join me again for lesson 3, all things collection. This is just a small taste of a much larger class. You can take the full class for free at levelset.com. Join me.